Coming out of mediation today, and one of the central issues was this premarital property that the husband had purchased about a year before they got married, and the parties lived in that property during the time that they were married. And the husband was paying the mortgage is in his name, the deed is in his name. The wife's convinced that she's entitled to some portion of the equity in the home. So the question becomes, is she really? Well, the way that this gets evaluated is about passive appreciation. It's also about the decrease in the mortgage. So if your mortgage has decreased, if you've paid down the premiums with marital funds, which would be your income during the period of time that you're married, then the non-owning spouse may be entitled to a portion of that pay down on the mortgage. There is a formula that is pretty complicated. It used to be under a case called KAA, K-A-A, and now it's part of our statute. But if you're living in a home that was owned pre-marriage by one of the spouses and you have used marital money to pay down the mortgage or to passively increase or appreciate the amount of equity that's in the home, then there may be some entitlement there. It's something you definitely want to get in touch with an attorney about. Here's a little legal lesson from today's mediation. If you have a non-marital, premarital asset, for example, like a settlement that you've gotten or an inheritance or something like that, you take that money and you purchase a home during the marriage. You put the deed to the home in your name, but you use the non-marital money to purchase the home, and then you guys live in it together. The other person is not necessarily going to be entitled to half the equity in the house, but they are going to be entitled, very likely, to half of the growth in value of the home. So if you purchased it for $500,000 and now it's worth $1 million, that's $500,000 worth of growth since the time that you purchased the home. That growth in value is going to be considered marital. So now we go into a divorce. What's the other person going to be entitled to? Well, if the growth in value is marital and the growth in value is $500,000, then the other person's going to be entitled to half of that, which would be $250,000. If the parties in a divorce proceeding purchased property during the marriage, but it's titled only in one person's name, the other person who's not on title may have an equitable interest in the property, meaning they may be entitled to some money value out of that property, but they don't have a legal interest. They're not on title, so they don't have the ability to force the sale of that property. They don't have the ability to make decisions about the property. They might have the ability to get exclusive use and occupancy of the property during a divorce proceeding if they're the primary caretaker of the children, but they do not have legal rights to the property.